GST on royalty for mining lease, cites pendency before Supreme Court and accordingly stays the matter. Finally, the stay on GST payment for mining lease royalty will continue. See section 158. Subsequently, section 158 also has section 158 subsection 3. But despite being unregistered, the firm held GST registration and paid taxes, recomputed the limitation period for passing adjudication orders under Rule 86A, cannot operate as a recovery mechanism. The Orissa High Court quashed the SCN, show cause notice. GST Judicial Outlook for the week. My dear friends, GST Judicial Outlook number 1 is with respect to Bombay High Court judgment. Bombay High Court in Rushiraj Infra versus Union of India and others, writ petition number 6135 of 2025 has held that GST on royalty for mining lease cites pendency before Supreme Court and accordingly stays the matter. My dear friends, the facts of the case is the Bombay High Court Nagpur bench granted interim relief to Rushiraj Infra, staying the payment of GST on royalty paid for minor mineral mining leases. My dear friends, the court followed the Supreme Court's interim order in Lakhvinder Singh versus Union of India, where similar relief was granted by staying GST liability on royalty for mining rights. My dear friends, the court noted that the Supreme Court had earlier stayed the levy of service tax on royalty payments, reinforcing consistency in judicial approach towards taxation of mining royalties. Recognizing that similar interim reliefs had been granted in connected matters by the same High Court, it found no justification to deviate from its established view. Finally, the stay on GST payment for mining lease royalty will continue until further orders. The matter has been listed for detailed hearing after Diwali for further consideration. GST Judicial Outlook number 2 is with respect to Bombay High Court judgment. Adarsh son of Gautam Pimber versus State of Maharashtra, writ petition number 11135 of 2025. It has been held by the Bombay High Court. GST Act, being a special act, prohibits disclosing companies' returns under the RTA Act. The facts of the case is, the court held that the GST Act, being a special and later enactment, prevails over the RTA Act regarding disclosure of information. Hence, data prohibited from disclosure under section 158 of the GST Act cannot be shared under the RTA framework. My dear friends, under section 158, it has been provided for the benefit of all the listeners. I would like to quote the exact words of section 158. Section 158 deals with disclosure of information by a public servant. Section 158 subsection 1. All particulars contained in any statement made, written, furnished, or accounts or documents produced in accordance with this act, or in any record of evidence given in the course of any proceedings under this act, other than the proceedings before a criminal court, or in any record of any proceedings under this act, shall, save as provided in subsection 3, not to be disclosed. My dear friends, section 158 subsection 2. Notwithstanding anything contained in the Indian Evidence Act 1872, 1 of 1872, no court shall, save as otherwise provided in subsection 3, require any officer appointed or authorized under this act to produce before it or give evidence before it in respect of particulars referred to in subsection 1. My dear friends, this is about the section 158. Subsequently, section 158 also has section 158 subsection 3. But the point here to be noted, it is completely prohibited under section 158 of the GST Act to share any information under the RTA framework. My dear friends, the court clarified that GST return of companies, firms constitute third-party information. Very, very important. It constitutes third-party information protected by section 8, subsection 1, clause D, section 11 of the RTA Act. Any request for such data requires third-party notice and consideration of confidentiality before disclosure. So there has to be a consideration of the confidentiality before the disclosure of information if it is sought by the third party. The petitioner's general allegations of fraud were found bald and unsupported. The court emphasized that disclosure of third party tax data under RTI is permissible only when larger public interest is clearly established and not merely alleged. My dear friends, relying on the Supreme Court view in Subhash Chandra Agrawal, the court reiterated that third-party commercial and financial information is inherently confidential, and RTA officers must protect such data unless overriding public interest demands otherwise. Under the same case, it has also been held that finding no evidence of public interest or procedural lapse, the court upheld the orders of the Information Officer, Appellate Authority, State Information Commissioner, rejecting the RTA application. The judgment reinforces that GST return data cannot be accessed through RTA mechanism except in exceptional justified circumstances. It has been held by the Bombay High Court in Adarsh, son of Gautam Pimper versus State of Maharashtra, writ petition number 11135 of 2025. GST Judicial Outlook number 3. My dear friends, this is with respect to Kerala High Court judgment wherein US Technology International Private Limited versus State of Kerala and others, WPC number 14760 of 2025. My dear friends, the High Court has held necessary documents admissible before Appellate Authority despite non-production at adjudicating stage. My dear friends, the facts of the cases, the Kerala High Court held that under Rule 112, Subrule 1, Clause C of the CGST rules, an appellant may produce new evidence before the Appellate Authority if prevented by sufficient cause from producing it before the adjudicating authority. My dear friends, the court recognized that the assessee's failure to furnish documents before the Deputy Commissioner, SGST, was due to the voluminous nature of transaction and short time granted for compliance, constituting a valid and sufficient cause under Rule 112, Subrule 1, Clause C. Emphasizing the objective of GST adjudication, the court observed that the process aims at determining the correct tax liability, not penalizing taxpayer or recovering tax that is not legally due. The court clarified that appellate proceedings are not adversarial but a continuation of the original assessment process. Therefore, the Appellate Authority is empowered and expected to examine new evidence relevant to determining the correct tax liability. My dear friends, setting aside the Appellate Authority's rejection of the rejection plea, the High Court directed to reconsider the appeal on merits, accept the additional documents, adjudicate fresh, aligning with principles of natural justice and substantive fairness. It has been held in US Technology International Private Limited versus State of Kerala and others. GST Judicial Outlook number 4 is with respect to Delhi High Court judgment Amit Kumar Basu and others versus Sales Tax Officer Class 2 Avato Ward 13 Special Zone 12 Delhi and others, WPC number 15327 of 2025. It has been held by the Delhi High Court, tax-paying unregistered partnership firm can challenge GST demand, Partnership Act imposes no bar. The facts of the case is, the Delhi High Court held that a writ petition filed by an unregistered partnership firm under GST law is maintainable, particularly when a partner is also impleaded as a co-petitioner. The court clarified that Section 69, Subsection 2 of the Indian Partnership Act 1932 does not bar proceedings by an unregistered firm when the action seeks to enforce statutory and common law rights as opposed to contractual rights. Despite being unregistered, the firm held GST registration and paid taxes. Hence, the court ruled that such an assessee cannot be denied enforcement of statutory right or remedies against the department just because it is unregistered. The court relied on Haldiram Bhujiawala versus Anand Kumar, Deepak Kumar and Shiv Developers versus Akshare Developers, reinforcing that unregistered firms may pursue statutory claims and are not barred from litigation on that ground. The High Court directed the assessee to file an appeal with the requisite pre-deposit, condoned the delay and made the matter subject to the outcome of the Seren's Heavy Lift India Private Limited proceedings, where the validity of notification number 40/2021 central tax is under challenge. This was held in Delhi High Court, Amit Kumar Basu and others versus Sales Tax Officer. GST Judicial Outlook number 5. It is with respect to Andhra Pradesh High Court judgment, SJ Constructions versus Assistant Commissioner WP number 11028, 11206, 17671 and 20792 of 2025. My dear friends, the facts of the cases. The court held that issuing a single show cause notice or composite assessment order covering multiple tax periods or financial years is not permissible under the GST law. Each assessment year or tax period must be adjudicated independently. Very, very important. As clubbing multiple periods together violates the statutory framework for adjudication and assessment under the GST regime. A composite order adversely affects the taxpayer's right to appeal is provided under Section 107 and the right to seek waiver of penalty or relief under Section 128 since these remedies are exercised period-wise. The petitioner also challenged orders for being unsigned, lacking of document identification number, reinforcing that procedural compliance is a mandatory requirement for the validity of the assessment orders. The court set aside the impugned composite orders while granting liberty to the tax authorities to initiate fresh, separate proceedings for each assessment year in accordance with law. GST Judicial Outlook number 6 is with respect to Guwahati High Court judgment, Shahul Hamid versus Union of India, WPC number 4767 of 2025. It was held in this High Court judgment. Summary of show cause notice issued in form GSTR DRC01 does not substitute proper SCN required under Section 73 subsection 1. It was been held by the High Court. My dear friends, the facts of the cases. A valid SCN under Section 73 subsection 1 must clearly state the factual and legal basis of the proposed demand. Merely issuing a summary in form GST DRC01 or attaching a tax computation does not fulfill the statutory requirement. The show cause notice enables the taxpayer to effectively respond. Its absence vitiates the entire proceedings. My dear friends, Section 73 subsection 1 and Section 73 to subsection 2, Section 73 subsection 3, Section 73 subsection 4 make a clear distinction between an SCN, a statement and DRC summaries. Even when a statement under Section 73 subsection 3 is issued, a separate SCN is still required. Rule 142 mandates DRC01, DRC02 only as supplementary summaries, not substitutes for the primary detailed notice or statement. Attachments and summaries bearing only signed proper officer without digital or e-sign authentication are invalid. Under Rule 26, Sub-Rule 3, electronic authentication by the proper officer is compulsory. Courts have extended this requirement to demand and recovery proceedings to uphold legal validity. Unsigned or unauthenticated notices, orders cannot be curated by Section 160 or Section 169 of the CGST Act. Section 2, subsection 91 and 73 collectively, as you read together, mandate that all notices, statements and orders must be issued and authenticated by the proper officer. Failure to do so renders such documents unenforceable. DRC summaries lacking such authentication cannot confer jurisdiction or replace duly signed statutory documents. Even if the taxpayer does not file a reply, a personal hearing is mandatory whenever an adverse decision is contemplated. Leaving the hearing column blank in DRC01, passing an ex parte order violates Section 75 subsection 4 because it mandates personal hearing and principles of natural justice. Consequently, the order under Section 73 subsection 9 was set aside with the liberty for de novo proceedings. The limitation period stands excluded accordingly. It was held in Guwahati High Court, Suhail Ahmed versus Union of India, WPC 4767 of 2025. GST Judicial Outlook number 7 is with respect to Orissa High Court judgment, Tansam Engineering and Construction Company versus Commissioner, CGST Central Excise Rourkela, WPC number 15935 of 2025. My dear friends, in this case, the show cause notice, not summons, marks initiation under section 6, subsection 2, clause B. Parallel GST proceedings are barred for same liability, held the High Court. My dear friends, the facts of the case here is, the court held when both state and central GST authorities act on the same subject matter. Very important. When both state and central GST authorities act on the same subject matter, identical suppliers, transactions and tax periods, only that authority that initiated section 74 proceedings first can continue. Any subsequent proceedings by the other authority are barred under section 6 subsection 2 clause B of the CGST Act. We all know that because it's a mutually exclusive proceedings on the same subject matter. Very, very important. Here, since the proper officer had already initiated enforcement under section 74 through DRC 01A in July 2021, later DGGI action on the same issue was invalid. CBEC's 5th October 2018 circular also mandated that the authority initiating the case carry to its logical conclusion. The court clarified, relying on Armor Security India Limited versus CGST Delhi East Commissionerate Supreme Court judgment, that summons or inquiry under section 70 does not constitute initiation of proceedings. Proceedings formally begins only upon the issuance of a show cause notice under section 74. The subject matter for applying section 6 subsection 2 clause B was interpreted as the tax liability or deficiency arising from a specific contravention. Thus, where both authorities pursue recovery for the same alleged wrongful ITC or transaction, set concurrent adjudication is permissible. Since the central proceedings, that is show cause notice, order in original, DRC 07, mirrored the prior state action, they were declared invalid, inoperative, non-est. The writ petition was allowed, reaffirming that cross-empowerment does not override the statutory bar against parallel adjudication. It was held in Orissa High Court, Tansam Engineering and Construction Limited, Construction Company versus Commissioner, CGST Central Excise Rourkela. GST Judicial Outlook number 8 is with respect to Madras High Court, YSS Cybernetics Private Limited versus State Tax Officer. My dear friends, in this case, Madras High Court dismisses appeal against Tata Play ruling applying Supreme Court's COVID order for recalculating limitation. The facts of the case is, the Madras High Court affirmed that the Supreme Court suo motu order excluding the period March 15, 2020 to February 28, 2022 continues to apply for computing limitation periods in judicial and quasi-judicial proceedings under GST and other laws. The court dismissed the assessee's writ appeals, upholding the single judge's interpretation that the court dismissed the assessee's writ appeals, upholding the single judge interpretation that the Supreme Court's exclusion period remains valid despite the latest introduction of section 168A of the CGST Act, which provides for an extension of time during force majeure events. The court clarified that Supreme Court's order relates to exclusion of limitation, whereas section 168A notification deal with extension of time. These operate in different legal fields, and therefore Supreme Court's exclusion order continues to govern limitation computations. The single judge held that notification number 9/2023, 56/2023 issued under section 168A were vitiated and illegal, as they could not override or dilute the exclusion of time already provided under Supreme Court's suo motu order. My dear friends, applying the Supreme Court's exclusion directive, the High Court recomputed the limitation period for passing adjudication orders for 2017-2018, 2018-2019, confirming the time between March 15, 2020 and February 28, 2022 must be excluded from the limitation calculation for such proceedings. It has been held in Madras High Court, Oasis Cybernetics Private Limited versus State Tax Officer. GST Judicial Outlook number 9 is with respect to Supreme Court judgment, Principal Commissioner versus Best Corp Science. My dear friends, it has been held in the Supreme Court wherein Supreme Court issues notice against Delhi High Court judgment over negative blocking of ITC under Rule 86A. The facts of the case is, the Supreme Court issued notice in a special leave petition, SLP filed by the Revenue challenging the Delhi High Court's judgment that quashed the negative blocking of input tax credit in the electronic credit ledger and beyond the balance actually available. The Delhi High Court emphasized the precise wording of Rule 86A Sub-Rule 1, specifically the phrase not allow debit of an amount equivalent to such credit in the electronic credit ledger, and held that it only empowers authorities to restrict utilization of the existing ITC, not to create a negative balance. Applying the literal rule of interpretation, the court found no ambiguity or absurdity in the rule's language and concluded that it cannot be stretched to authorize blocking ITC that does not exist in the ledger. My dear friends, the court clarified that blocking ITC under Rule 86A cannot operate as a recovery mechanism. Any action requiring the taxpayers to replenish ITC already utilized would ineffectively amount to tax recovery without due process, which is impermissible under the GST framework. My dear friends, the Delhi High Court disagreed with the Calcutta High Court's view in Basanta Kumar Shah and instead aligned with the Gujarat High Court's ruling in Same Alois, reinforcing that Rule 86A cannot be invoked to create a negative balance in the taxpayer's electronic credit ledger, and it has been held by the Supreme Court in case of Principal Commissioner versus Best Corp Service. GST Judicial Outlook number 10 is with respect to Orissa High Court judgment, Tansam Engineering and Construction Company versus Commissioner of CGST and Central Excise and others, WPC number 15935 of 2025. My dear friends, it was been held by the Orissa High Court. Parallel proceedings by proper officer on matter already initiated by the state authority, invalid. The facts of the case is, the Orissa High Court quashed the SCN, show cause notice, issued by the TGGI, that is Central Proper Officer, and consequential order holding that once the proper officer has initiated proceedings on the same subject matter, any subsequent proceedings by the Central Proper Officer was barred under Section 6, Subsection 2, Clause B of the CGST Act. My dear friends, the court agreed with the assessee that initiation of parallel proceedings by both central and state authorities for the same alleged wrongful input tax credit claim could amount to double taxation, which is expressly prohibited by Section 6, Subsection 2, Clause P. Referring to the Supreme Court's ruling in Armor Security India Limited, the High Court clarified that the issuance of summons under Section 70 does not constitute initiation of proceedings. Therefore, state's show cause notice under Section 74 marked the actual initiation point, rendering the later central SCN invalid. The court relied on CBIC's DOF number CBEC 20/43/01/2017, GST Circular File number CBEC 20/10/07/2019, GST, which reinforced that once one authority, state or central, is seized of a matter, the other cannot reinitiate proceedings on the same issue on the same subject matter. Since the central SCN, my dear friends, since the central SCN was held invalid, the court ruled that the entire proceedings and the resultant order in original fell with it, applying the principle that where the foundation SCN is void, the entire structure order collapses. It was held in Orissa High Court, Tanzam Engineering and Construction Company versus Commissioner of CGST and Central Excise and others, WPC number 15935 of 2025. That's all for the week. Signing off, Advocate Dr. M. Sathya Kumar. Thank you.